Maybe I'll wait for 2 minutes. Start? Yeah, I was just waiting. Okay. Good morning, everyone. So today, what maybe we'll start with is getting into a little bit more about privacy law in India. You've already heard at the previous lecture an overview of what is privacy and what are the various elements of privacy as it relates to cyberspace or to the internet. But today we'll get into a little more detail in regarding the law in India. For that, let's start with an exercise. All of you are probably aware or would likely be aware of the Aadhaar card, right? Everyone's familiar with the Aadhaar card? Right? Everyone probably has an Aadhaar card. The entire Aadhaar card process, as you know, was started a few years ago. And as part of that process, the government was collecting information, right, from all of us so that we can get an Aadhaar card. The Aadhaar card was a huge project, if you remember from a few years ago. It's a huge project. It's a giant task, right, trying to provide ID cards to all of the citizens and residents of India. That's over 1 billion people. So that's a huge exercise. And the purpose of the exercise, as you may remember, was not just to provide ID cards, right? The idea was so that the government could provide its social welfare schemes, whether it's providing ration or whether it's providing direct subsidies, monies from, let's say, the Jawahar Rozgar Yojana, so that they could transfer the amounts directly to bank accounts of the people who were entitled to get them, right? So the idea seemed to make sense, right? Obviously, ration card used to be the identification for most people. Some people had passports, but that was really not a large population. But real identification for most people in India, maybe driver's license, but only if you had a two-wheeler or a four-wheeler or something. But for most people, it was ration card. And so the idea was, let's move to some sort of digital format of being able to identify people, know where they live, and therefore provide social welfare to all of the people who are entitled to those. So it makes sense, right? It's one digital ID that we all now have, all of us who have Aadhaar cards. And it's super helpful. You can use an Aadhaar card now as a form of identification to get a phone line. You can use it as a form of identification if you are traveling by train. You can show your Aadhaar card for the ID. If you're traveling by flight at security, you can show your Aadhaar card. So it's at hotels, when you check in, they ask for ID, Aadhaar card works. So it's a government recognized digital form of identification. Super helpful. If you remember, when they started issuing Aadhaar cards, the information that you had to go to the office, and sometimes they would have these information collection drives. It was a big push, right? Because huge project, getting 1 billion plus people onto the system. So they had people, volunteers and others, just like when we do voting, they had drives. People go to apartment complexes, set up stalls that you could just go to the stall, provide your information, and then ultimately the Aadhaar card would finally arrive to your location. And then they had all of these offices where you could go apply for an Aadhaar card. As part of that information, they would ask you for current identification, some identification, marriage certificate, birth certificate, SSLC certificate, whatever, some identification to show that you are who you are, some identification to show your address, ration card if you already had a ration card, things like that. And they would also take your fingerprint scan, right? So here's a question for you now, before we get into discussing the application of law. as I said, for giving you an Aadhaar card, they collected all of this information. As you can imagine, all of this is personal information. They collected your phone number, they collected your address, they collected your fingerprint scan, right? You had to give all of this information to the government in order to get an Aadhaar card. And there was a time when getting an Aadhaar card was also, basically it was mandatory. Because if you didn't have an Aadhaar card, you couldn't do anything. You couldn't get a new phone connection. You couldn't open a new bank account. If you wanted a new bank account, the first thing they would ask is, where is your Aadhaar card? So can't open a bank account, can't get a new phone. Whatever you wanted to do, you needed an Aadhaar card. So everybody was scrambling to get this Aadhaar card, right? And so for this Aadhaar card, you were giving up your personal information to the government. You were giving them your personal information, your address, your fingerprints, and so on. So is that not a violation of privacy? Yeah? So is that okay? Why is that okay? Any thoughts? We all voluntarily gave our personal information to the government. The government has all our data. It knows exactly where we live, knows our phone number, has our fingerprints, can track us using all of that at any time. Effectively, it has a database that has our personal information. Is that not a violation of privacy? And if it is a violation of privacy, how come we've all said okay to it and none of us have any concerns, issues? Anybody have any concerns or issues with the government having that data about us? And none of us are criminals, so none of us care. It's okay. What do I have to fear? Right? Okay, but there were at least some people who were concerned. Not because they were criminals, but because they were concerned that we are giving this private information to the government. And worse, it's not as if there was really any choice in the matter. If you did not have an Aadhaar card, you pretty much could not live your life effectively in India. You still can't. Without an Aadhaar card, it is very hard to go about your daily life. It's possible, but like I said, it's not easy. It's much easier to just have an Aadhaar card and get on with life. So, what is this? There was a retired judge, a retired High Court judge in Karnataka. He filed a case against the whole Aadhaar system. And this was at the time when they had just rolled out the Aadhaar process. They were collecting all this information. It was all done under this law called the Aadhaar Act. So, retired Justice Puttaswamy from Karnataka, from Mysore, he said this is unconstitutional. That was his argument. You cannot force me effectively to give up all my personal data. This, he said, was a breach of privacy. The reason it went up to the Supreme Court, so the Supreme Court ended up hearing this case, was because the Constitution doesn't say expressly anywhere, meaning explicitly, in the Constitution, there are no words that say you have a right to privacy. There is no constitutionally recognized right to privacy if you just read the Constitution as it is. So now, you are all the judges of the Supreme Court. What do you think? The Aadhaar Act says you need to provide all this information. The Constitution doesn't expressly say, doesn't in words anywhere say that there is a right to privacy that all residents have. If you are the judges of the Supreme Court, what would you do? How would you resolve this? We know that we all have Aadhaar now, so obviously the law, the law wasn't completely abandoned or anything. But what do you think? Do you think, where is this right to privacy then coming from? You're talking about privacy and so on and so forth. Where is this right to privacy coming from? Okay, let me give you a hint. There is an article of the Constitution that says we have the right to life and the right to liberty. Liberty means freedom, right? Right to life and right to freedom. Does that help us? Any thoughts? Let the individual choose. Yeah, freedom means not just freedom to walk around here and there physically, right? Not just physical freedom, but it could mean freedom of choice, right? Any other thoughts? Okay, so that's what the Supreme Court finally said. Article 21 provides for the right to life and liberty, and the Supreme Court said that includes a right to privacy. Because a right to life doesn't just mean a right to live, meaning exist. It's not just that, okay, nobody can just, imprison me or kill me for no reason. That's not, when the Constitution says right to life, it means more than just existing. It means a right to a dignified life, right? Which includes other things like right to a healthy environment, right to have opportunities, right? And same way, right to life and right to liberty. Liberty simply does not mean, or freedom does not simply mean the right to walk around wherever I want to. Obviously, when it's not somebody else's private land or property. But it means, it doesn't just mean that the government cannot impose restrictions on where I can go and where I cannot go, right? It means the right to choose. Right? Liberty means the right to choose, and it means the right to then have control over myself. And that right to control over myself includes things belonging to me. So control over my things. And my things obviously mean physical things, but it also means my identity. Who am I? Where do I live? What is my phone number? My fingerprints. So I should have control over what I do with my own identity, my own personality, my own personal things. So that's what right to privacy means. So to elaborate, they've said it means it covers intrusion or not intruding into somebody's physical body. Obviously, that's a right to privacy means I have a right to keep private my own body and my own self. If I want to go hide somewhere for 10 days, I should be able to hide somewhere for 10 days. If I want to sit in my house for 10 days and not see anybody, I have the right to sit in my house for 10 days and not see anybody. It includes the right to informational privacy, right? What information that I choose to give about myself or what information I choose to consume is my own right. I should be able to decide. Somebody shouldn't be deciding for me what I can see, what I can read, what I can hear. And same way, the flip side is nobody should be feeding me only one certain kind of things that I can read or understand. And then, as we talked about, the privacy of choice, right? The right to choose what you want to do with your own identity. Okay, so that's what the Puttaswamy case basically was about. So, having said that, right, that's how the Puttaswamy case is in the Supreme Court in 2015 held that the right to privacy, even though it is not expressly written anywhere in the Constitution, it can be read into the fundamental right to life and liberty under Article 21. And under the Constitution, there is this concept of fundamental rights. Fundamental rights are rights which cannot be taken away. Right? The Constitution has a set of fundamental rights, and they are called fundamental because they are fundamental to yourself, the country, and the notion of government and the notion of the Constitution under the Indian form of government, under the way in which our governance system works. Having said that, it is not an absolute right. What does that mean now? So let's go back to the Aadhaar case, right? We know we all have an Aadhaar card. So obviously the law, it still existed and the whole project went ahead. On what basis do you think then, if we have a fundamental right to privacy, on what basis can the government then, how could they have collected all this Aadhaar information and collected all our personal information? What would be the logic there? Sure, voluntary commitment, yes, that's one possibility. As a Supreme Court judge, you could have said, well, it's your choice. You want to give them the information, give them the information. Don't want to give the information, you don't get an Aadhaar card. Your choice. So, to talk about this a little more, let's go back to what Article 21 says, right to life and right to liberty. And we said right to liberty means not just the right freedom to move around, but freedom to make choices. Okay, so if I have the right and the freedom to move around, liberty, go wherever I want to go, right? I want to go from here to Delhi tomorrow, government can't stop me for no reason, right? But then how does criminal law work? Isn't criminal law unconstitutional because it restricts my liberty? When the police comes and says they are arresting you or detaining you for inquiry to question you about something, that's restricting my liberty, right? But Article 21 says right to life and liberty. In fact, when they are detaining me and putting me in jail, that is not dignified life. How is that life? That's existing. And that is certainly taking away my liberty, because I don't have freedom anymore. I don't have freedom to physically move. Forget all these other freedoms about choice of what to do with my information and so on. It's a basic freedom, freedom of movement, right? So the Constitution says right to life and liberty, then how come we have criminal laws that lets the state, the government, the police, stop us from moving from one place to another? Any thoughts? Thankfully not. That's why we have a constitution, right? The government has a freedom to do a lot of things, but through due process of law. So Article 21 goes on to say, yes, you have the right to life and right to liberty, except it can be curtailed following due process of law. And that's exactly why, because think about it, if we had a unrestrained and absolute right to life and liberty, then there cannot be any criminal laws, because automatically that creates restrictions on my right to life, right to liberty, freedom of choice, freedom of movement, all of that, right? So yes, these are fundamental rights, but they are constrained by saying, if there is law that is properly passed by Parliament, then that law can restrict your fundamental rights, your right to life and right to liberty. And that's what criminal laws are. Criminal laws restrict your right to life and liberty, but they are laws passed by Parliament. Okay, so can Parliament pass any law that says, okay, tomorrow everybody living in Trichy, you cannot move out from Trichy? It's a fair law. It's passed by law. Parliament has said, passed by law. You are Supreme Court judges once again. You know there is a fundamental right to life and liberty, but you also know that a law passed by Parliament can restrict those rights. What do you do? Is that okay? Okay, so you say that's fine. Government doesn't have to provide any reason. They have said everybody in Trichy has to stay in Trichy. Next they say everybody in NIT Trichy who is right now in NIT Trichy has to stay within NIT Trichy. Cannot move out.
What do they call that? Is it national security? For national security, we make these laws, and that becomes basic.
Yes, So national security is one wonderful exception that is used by governments all over the world to do all kinds of things. During COVID there were clampdowns, there were restrictions. Exactly. So there are situations when the government has done this. And there are, sorry, go ahead. Emergency. Yes, we have emergency, periods of emergency when the government can take over and pass laws that restrict our freedoms, including some of our fundamental rights. But what if the government says, I just felt like all these people who live in Trichy, they are not nice people, so we'll keep them in Trichy. Don't let them go anywhere and spread all these ideas that they have, especially ideas that they learn at NIT Trichy, we should not let them spread anywhere. They learn about things like privacy and all that. That's not a healthy behavior. We'll keep them all in NIT Trichy, let them have their privacy in NIT Trichy, right? No need for them to spread all these ideas about privacy outside of NIT Trichy. So that's the reason. What do you think as a Supreme Court judge, or what would you do? Good enough reason? Do they need a good enough reason? Do they need a reason at all? We've talked about reasons, right? We talked about COVID, okay, pandemic. Emergency, okay, why emergency? Maybe they can explain why emergency. We've talked about national security, okay, there is a war going on, maybe national security. But what about this example? For better administration, okay. So tomorrow, if the government says this, does this, you think that would be okay? Forget about law. Let's go to ethics, morals, and all of that. You're okay. Okay. Anybody else? Let's take a poll. How many people think it is okay for the government to pass such a law? I'm just saying okay, right? I'm not saying is it legal, is it constitutional, whatever. In your mind, is it okay? Okay being whatever you call morals, ethics, fairness. Is it okay for the government to pass a law saying those who are in NIT Trichy right now have to stay in NIT Trichy for the next 5 years? Hands those who think is okay, raise your hands please. We have a dictator in the making. So all others think it's not okay. Okay, why is it not okay?
Because the government has to work on behalf of the people, for the well-being of the people.
Okay, when the elections come in 3 years, you can vote the government out, no problem. But till then, law is there.
Sir, because I want to meet my family in Chhattisgarh, so I cannot always stay in Trichy for 5 years, for the next 5 years.
Okay.
Plus, I would also want to look for job opportunities outside Trichy, so that's why I think the government, this law government is not okay for me.
Yep, okay.
Because everyone has the right to freedom. Even if criminal is there, if he's accused, he also has the right to freedom until he is convicted.
Sure. Yeah.
If they are convicted, they also right have.
Mm-hmm.
So everyone has the right to freedom, so they cannot control us.
How can horses do such things? Everyone has their rights to live freely.
Right. Okay. Any other thoughts? Why do you think this law is not okay? Anyone else? Okay, so yeah, I mean, when there is a law passed by the parliament, by the government in power, the touchstone, meaning what it is tested against, every law is tested against the constitution. So it has to pass the tests of the constitution, does it? And that's what we may say when a law is unconstitutional, right? The government does not have free power or freedom to just pass whatever law it wants, whenever it wants, however it wants, right? That is the entire point of the Constitution. The Constitution places restrictions on what the government can do and cannot do in terms of law, in terms of how they operate. That's what the Constitution does. That's why no government, no president is above the Constitution. The Constitution is the single document in our country, in our democracy, against which every law can and has to be tested, or can be tested, right? So going back to this example, right? So why do we allow criminal laws, but why do we think it's not okay to have a law? Most of us think it's not okay to have a law that would restrict our freedom in this manner. It goes back to what due process is. Due process of law. Due process doesn't just mean has it been passed by Parliament, following the due procedure of passing a law. It also means, is the law reasonable? Is the law fair? This is where concepts of fair and reasonableness and all of that, is it arbitrary? That's what the Supreme Court then looks at when judging whether a law is passed through due process, right? The Constitution does not give you, language to cover everything, and that's what the judge's job is. To evolve and interpret the Constitution for it to make sense in the context. So if we had, exactly right, and most of it is sort of logical, right? Most of us think it's not okay for the government to pass a law which has no reasonableness to it, which has no justification to it, which seems to be just arbitrary, no rationale to it. Right? If there's an explanation, there is an epidemic in NIT Trichy. We want to contain that epidemic here. Therefore, we are saying everybody who stays here everybody who is here right now has to continue to stay here. That would be okay. Would that still be okay for 5 years? Probably not. It's not reasonable. If you have an epidemic, you can probably figure out how to fix it, how to cure it, all of that in 3 months, 6 months, whatever. So that may be reasonable. Right? So going back to the other situation now. Now that you know that not only do we have these fundamental rights, there can be exceptions to that by due process of law, but due process means fair, reasonable, something that is not arbitrary. Now you are again the judges of the Supreme Court. What would you say about the Aadhaar collection process? Any of you think that is constitutional, unconstitutional? Let's have a poll again. How many of you think now that the Aadhaar Act should remain constitutional and this collection of all of this information is now constitutional, going through this process? Yeah? How many of you still think it's unconstitutional, unfair? So that's what the Supreme Court held, right? Yes, you have a constitutional right to privacy, and yes, there can be exceptions. It's not an absolute right. There can be exceptions if there is a law which follows due process, which is fair, which is reasonable, which is not arbitrary, then your privacy rights can be curtailed. And they said the Aadhaar Act does that. It is a reasonable law because it has a process, it has a procedure, it has a rationale. There is a justification to why they are collecting all this private information. It is to be able to provide A, identification, B, to be able to provide social welfare schemes, right? And C, there are technical technical guardrails. So if your fingerprint is collected, then it is maintained in a particular database. The database has security. It cannot be just used for whatever purpose the government wants. It cannot be sold by the government to somebody else. So there are security measures around it. And you're going to hear again later from Professor Dasrathi about security features, right? And you're going to talk about security features and so on. So here's the linkage between law and the actualities of maintaining data security. data security is not just important because there are commercial reasons for it to be kept secure. There could be legal reasons why it's important to keep your data secure. Okay. Just keep a check on time. Talked about that. Okay, so just going back to Puttaswamy case once more, they said that the test to determine whether there's an invasion of your right to privacy, they laid out 3 tests. One is, it should be in the form of a law or a rule or something like that. Second, it needs to meet a legitimate state interest. We talked about that. And third, it must meet the test of proportionality, meaning the restriction on your right to privacy must be proportionate to what the state is trying to achieve, what the government is trying to achieve. Again, in the example of keeping people hostage or confined to NIT Trichy, it would be disproportionate to say that there is a pandemic and therefore we want you to stay here, but you have to stay here for 5 years. Obviously, that is not proportionate to what they are trying to achieve. What they are trying to achieve is contain the pandemic, right? I mean, and that we talked about was a physical restriction, but obviously you can have other kinds of privacy restrictions in that case, right? You can think about the government in this situation trying to collect health information from all those in NIT Trichy. Every day they are going to come and, just like they did in COVID, right? Every day they are going to come and check your temperature. Every day they are going to come and take a blood sample. Every day they are going to regulate what you eat. Every day they are going to regulate who you meet. All of those are privacy violations. But all of those can be justified if the reason for which the government is doing that is justifiable. If it seems to be reasonable and in the greater public good. And then yes, of course, it could be because of national security. That could be a reason, and so on. Okay, let's talk about, so going from the constitutional right to privacy, let's talk a little bit about privacy under Indian legislation. So there is something called the Information Technology Act. Let me just one more thing that I had in my notes here, so I want to point that out. Under the Aadhaar Act itself, because we talked about the Aadhaar Act and the Puttaswamy case for this long, I just wanted to complete the story. Under the Aadhaar Act itself, the Supreme Court did point out that there were a couple of aspects which violated the right to privacy. One was, at that time, under the Aadhaar Act, part of the Aadhaar process was mandatory linking of your Aadhaar account to your PAN card and mandatory linking of your Aadhaar account to Aadhaar number to your bank account and to your mobile number. All of that was mandatory. And the Supreme Court said no, that part is unconstitutional. Because the government is trying to, the logic the government gave was, we are trying to provide social services to all of those who have an Aadhaar card, and this is going to form a kind of identification. So mandatorily having everyone link their PAN card, which is used for tax purposes, to your Aadhaar card is disproportionate, right? It doesn't serve the justification that the government is providing. Why should my tax account be linked to my Aadhaar account? The government could have argued that, well, we need to make sure that these people are below a certain tax level to be able to provide them the social welfare schemes and so on and so forth. But basically the Supreme Court at that time said no, this can be voluntarily provided. If individuals want, then they can voluntarily link their PAN card to their Aadhaar card and all that, but it cannot be made mandatory for everybody. Okay. Another provision that they said was unconstitutional was a provision under the Aadhaar Act that allowed private companies to use the Aadhaar number for any purpose that the company wanted to use it for. So the Aadhaar number of their employees could be used for whatever the company chose. And the government again, the Supreme Court again said that is unconstitutional because there are no guidelines, there are no safeguards under the law. It just gave a free hand to the private companies to use the Aadhaar number for anything. Even now employers do collect Aadhaar, right? Again, as a form of identification. They do collect your Aadhaar number. But they have to have rules and regulations and guidelines around what they can use it for, what they cannot use it for. Right? So at that time when the law was drafted, there were no rules around or any restrictions around what private companies could use that Aadhaar number for. And so it was struck down as unconstitutional. Okay. Okay. Sorry, one more thing on the Aadhaar card, and I'm going on and on about the Aadhaar card because I think it's a useful real life example of how our data is collected, has been collected by the state and is used. Right. So one of the judges, the then Supreme Court Chief Justice, he, in fact, while he held the while he said that we have a right to privacy, he in fact dissented, meaning he did not agree with the other judges in the Aadhaar card case, and this was 9 judges of the Supreme Court. Right. Among those 9 judges, each judge gave a separate decision. They all agreed that there was a right to privacy and all of that, but each one of them gave slightly differing judgments on what this right to privacy means, what are the tests, and so on and so forth. And the Chief Justice said that he in fact thought that the Aadhaar program was unconstitutional. Even though he thought it was unconstitutional, because all of the other judges thought it was constitutional, the Aadhaar program went ahead. So that's interesting because the reasons why he thought that it was unconstitutional was because he thought it was disproportionate. We talked about one of the tests. The taking away of your privacy rights has to be proportionate to what the state, the government is trying to achieve. He thought it was disproportionate. Right? He thought, why do you need all this information to be able to effectively provide social welfare services? You don't. There are other ways in his mind. There are other less intrusive ways. There are other ways by which, without taking so much private information, you should be able to provide all those services. So that's just an interesting observation, and also goes to show how it's not always clear when is it okay to take away your right to privacy and when it's not. Okay. Right. So under the so moving on from sort of the Constitution to looking at some more practical application of the right to privacy. Most of you have probably heard of our new privacy legislation called the Digital Personal Data Protection Act, or DPDPA. We will talk about the DPDPA in a few minutes, but before we get to this Digital Protection Data Privacy Act, or DPDP Act, which was passed in 2023, we'll talk about the IT Act, Information Technology Act. And the reason we'll talk about this legislation first, even though we have a new legislation that is focused on privacy, is because that legislation, the DPDP Act, is not yet fully in force. The Act has been passed by Parliament, but the Act says that it only comes into force, meaning it is in effect only when certain rules have been created by the government and those rules have been notified. And those rules have not yet been notified. The government has, in January, so last month, they set out draft rules for comment. So the government, when it passes legislation, sometimes it provides a draft of the law and asks for comment from the public. So you can, even as an individual, you can see what laws are being passed, what are the bills, a law before it's passed is called a bill. What are the bills that are presented in Parliament as drafted, and you might be able to comment on those bills. If you think that something is improper, incorrect, unfair, whatever, you can actually send a submission as an individual. You're allowed to do that. And the government is supposed to look at those comments and incorporate them, not incorporate them. You don't really have control over that process. Your real control is through who you vote. Right? Vote for. Those are your representatives. They are supposed to raise any concerns or issues. But you as an individual have the opportunity to look at draft rules, draft bills, and comment on them. So the rules under the DPDP Act are now out for public comment, and there is a public comment period. It's usually 30 days, 45 days, something like that. And once the ministry gets those comments back, they will review them, and then they will decide to modify the rules or not modify the rules, and then notify them, and that's when the DPDP Act is going to become law. Now, something like the DPDP Act has significance, obviously not just for individuals but also for companies that are dealing with personal information, right? And obviously you can think of, in the internet era, in our current sort of situation, a lot of companies that deal with private information are all of the large companies whose content we use and who use our personal data. Google, which knows when we are searching on Google where we are, or Google Maps, which knows as soon as we turn on Google Maps, it knows exactly where we are at any point during that journey, and where we started our journey, where we ended our journey, where we stopped in between, all of that personal information. Right? Obviously, Facebook or Meta, it knows what we are browsing, what we are reading. It gathers all of that personal information. Swiggy knows what we like to order on Friday evening as compared to Monday morning, right? So it has all of that information. Where are we ordering to? It knows where we are most of the time. We conveniently mark it home also, right? So it knows where we live. So there's lots of private information, personal information, that a lot of these services, which are very convenient, there's no denying that all these services are very convenient, right? But there's a lot of personal information that all these services have. And so under the DPDP Act, which we'll talk about in a minute, there are a lot of requirements that these companies have to comply with, and that's why they are very focused on being able to comment on these rules to ensure that their compliance obligation is something that they can meet. So they want to make sure that the law doesn't say things that is going to cost them a lot of money to comply with, or basically is going to kill their whole business, right? They don't want that. So that's why they are very interested in ensuring that those rules are that they are able to comply with those rules in the form that they come out. Okay, so the DPDP Act was passed in 2023, and that was the first legislation that first draft law that had a comprehensive overview of privacy, right? It talked about privacy in particular, one law talking about privacy in various aspects of life. Right? But before the DPDP Act, we still had some privacy related provisions in different legislation. And this is one example. Under the Information Technology Act, under section 43, individuals had the right to sue someone, to bring a case against someone for damages because of negligence in implementing and maintaining security practices and procedures with respect to what was defined there as sensitive personal data or information. So section 43 essentially gave individuals the right to sue a company if they did not have a policy. And you've been learning about policies, right? How to draft a privacy policy. Why is this relevant? Section 43 of the IT Act says, if a company uses private information and does not have a policy in place on how they are going to use that data, then you could sue that company for damages that you incur, right? Now section 43 talked about sensitive personal data or information. Sensitive personal data is again further defined, things that it's not just what's your name. While that is personal information, it wasn't considered sensitive personal information. Sensitive personal information is things like your health, your financial information. That is sensitive information. And you can it makes sense. Why is all that sensitive? Because you don't want the whole world to know what your health situation is at any given point in time. Obviously, you may tell your close family and friends. You may have a duty to disclose that to your insurer, but beyond that, you don't want the whole world to know what your health situation is for whatever reason, because that's personal information. Obviously, the same thing with financial information. You know how much you have in your bank account, the rest of the world doesn't need to know. So that is sensitive personal data, and if any company is gathering any personal information or sensitive personal information, they have to have procedures in place to maintain the security of that data. So obviously, your bank has to have policies in place to ensure that your personal data is maintained in a secure manner. Same way, your insurer or the hospital that you go to, which nowadays takes all your data and information, your MRI, your X-ray, whatever, and puts it on through their system, right? That is personal information. They have to have a policy in place that talks about, and that's why you are learning about privacy policies and how to draft a privacy policy. Why? Because these organizations need to have that privacy policy under law, or they are likely to get sued. How could they get sued? Let's say your personal data is leaked to somebody else. It's hacked, and somebody else hacks your bank's details, manages to get your password from them, and they manage to siphon off money, right? Obviously, that's a crime. It's a crime for whoever did that, but that doesn't help you if the police chases after them. Your money is gone. So who are you going to sue? You're going to sue your bank, because they didn't have procedures in place, they didn't have security measures in place, and so on, right? Okay. Yeah. Yes, so when you get to court and you sue them, then that will be one of the things that the court will look at. You can't obviously have a policy just for the sake of having a policy, have 2 pages or have a beautiful policy but not actually implement it, right? So those are obviously the things that the court will look at to say, okay, fine, you have a great policy, but where is it implemented? Where is it tested? Where is it tested before deployment? Are there audits on a regular basis? Is it actually working? All of those things, right? Yeah, a good question. So typically when you sue someone, whether it's for privacy or for anything else, you have to have suffered damages, right? That's the general rule, is if you have no damage, then what is your right to sue? What is your motive? Why do you care? That is the general principle. Having said that, we've all probably heard of PILs, or public interest litigation, and you can sue someone or bring a case against someone in the public interest. Typically, public interest litigation is not against another private company, because it's not necessarily in the public interest for a private company on the other side to do or not do something, right? It's usually against the state, against the government, to say, hey government, you didn't give me, the roads here are terrible and you aren't doing anything about it. That would be a public interest litigation. Okay, so the SPDI rules that I mentioned there are the rules that are rules under the IT Act that have more detail. SPDI stands for sensitive personal data or information, and they have more detail on these rules have a lot more detail on what are these practices, policies that companies have to maintain in order to comply with the Information Technology Act. And then there is also Section 72A of the Information Technology Act, which says that any person or organization who wrongfully discloses personal information without consent can be imprisoned for 3 years or fined up to 5 lakhs. So that is a criminal law. So it has criminal consequences, imprisonment of up to 3 years and fines up to 5 lakhs. So there's a criminal element there as well, right? Wrongful disclosure of personal information. And that can apply to any number of, that could apply to anyone who collects personal information, right? And that's why, again, it's important to have a privacy policy in place, because not only can you be sued under Section 43 for not having the right kinds of personal policies, but there can be criminal consequences if you are collecting personal information and without consent disclosing it, right? So there are criminal consequences to doing that. If you provide wrong personal information, then it depends on what that personal information is being used for. So obviously, as you know, for example, if you are providing incorrect personal information to your health insurer, you're going to get your health insurance denied, right? It could depend on, again, what it's for. Is it a misrepresentation? What is it for, right? There could be a legal impact if you are misrepresenting something, apart from being service denial. If there are concepts of breach of trust, criminal misrepresentation, so all of those things are what is the purpose, or what is the effect of your providing, or impact of your having provided wrong personal information. So when the shopkeeper, I don't know if you've had this example, this is happened to you, but when you go to a shop, and I was a few days ago, I had to buy a new cricket helmet for my son. So we went and bought it, and then he said, "Sir, phone number." What is for billing purposes? Why do you need it? For billing purposes. Why does he need my personal information for billing purposes? He doesn't. But instead of saying, "No, I'm not giving it to you," and I've done that sometimes, I give him the wrong phone number. Right? So are there consequences to me? Is that misrepresentation? Yes. Is that illegal? No. Is that what is the consequence? Right? There's really no consequence. Is there any harm suffered that he would suffer? No. Right? So and again, it's just an example. Just thinking of that example, it's an example of how you don't really think that much about private information, personal information, privacy, right? Hopefully now after this you'll all feel a little more sensitized about all of that and be a little more careful with your own personal information. Where do you think we get all these spam calls from? These fellows who have examples of people to whom we happily give our phone number without thinking twice, and then we wonder why we get so many spam calls. Okay, so let's, I think we have about 10 more minutes. I'll give you a brief overview of the DPDP Act. Even though, like I said, it's not yet in force, it will eventually come into force, probably later this year. And the DPDP Act is Digital Personal Data Protection Act, right? Digital, so as the name itself suggests, right, all relates to our digital lives. Digital Personal Data Protection. The DPDP Act generally follows the EU legislation on privacy. And the EU legislation is called the EU GDPR. Right? and follows those principles, the principles are generally two broad principles. We don't have to go into all of the detail of the law. It's very detailed, and if you want to read up more about it, there's lots of information online about the DPDP Act, right? But good enough for us, for our purposes, to know that it follows two main principles. One is that of consent, meaning anyone who collects our personal information. And the DPDP Act no longer, unlike the IT Act, which has a distinction between sensitive personal information and non-sensitive personal, DPDP Act just says personal information. Doesn't matter sensitive, non-sensitive, all of that. Personal information is personal information. So it could include sensitive information like health and financial records, but also non-sensitive information like our phone number or our email address or anything that can identify, any data that can be identified to us is personal information. Right? So it says the two principles that need to be followed are consent. Anybody who wants to gather or take or collect or use or process your personal information has to get your consent. A name alone by itself, yes and no, in the sense that a name alone by itself cannot identify you as an individual, right? You need a name and something else, usually, right? For you, probably not. And it doesn't matter how it's collected, whether it's on digital form or online, offline form, right? But so, for example, when you're providing your feedback forms, if you put your name down, I don't know if they're anonymous, maybe they are, but if you put your name down and you put your, even if you put your name down, in this context, it's identifiable. Because we know you were in this lecture, right? But if you just put your name down, filling out some other form to receive some newsletter, it's probably not personal data in that context because they probably cannot identify you. You're just using your name. So the two principles are consent. So any entity that collects your personal data needs to get your consent to collect it, to use it, to modify it, and when getting your consent, they have to tell you exactly what they are collecting it for, what they are going to use it for, are they going to modify it, how are they going to modify it, all of that. Right? So that the idea being you should be able to make an informed choice of whether you want to provide your personal data or not. There are further rules that talk about how for intermediaries like Facebook and platforms, they have to provide this information not only in English but in all of the scheduled languages under the Constitution. So, all of the regional languages, the major regional languages. The other aspect is that the use of that data must be legitimate. It must be a legitimate use. So that obviously, as you can imagine, means that whatever use that they are putting it for has to A, be legal, obviously, and B, also it has to be for some justifiable purpose. They can't just say we are collecting your data and we may use it for whatever purposes we deem fit. It's too vague, too broad. How can you give consent on whatever I deem fit, right? So they have to be very specific on what the use is going to be.
Like use, can there be an effective date? Beyond this, all that I give is lapse if really wanted to collect data.
Yeah. So it cannot, yes, there can be. Having said that, obviously companies, when they're crafting their consent forms, will try and keep it as open-ended as they can because they don't want to keep coming back to you to get your consent, right? I don't know off the top of my head whether there is any automatic, I don't think there is anything in the law that says your consent expires after X number of days or X number of years or whatever.
That's why the KYC banks keep coming back to you because I thought there's a period of
Yeah, so there are specific KYC requirements and regulations that apply to specific sectors. So in the banking sector, they have specific regulations on how they collect information. Updates. Confirm. Correct. Correct. The consent once, it could be forever for that purpose, right? And if you think about it from a convenience perspective also, let's say Facebook, when you log on to Facebook, you don't want to every 6 months, maybe you do, but every 6 months, Facebook doesn't want to send you a little pop-up saying, do you consent to the use of your information for this, that and that and that and that, right? Having said that, if when companies are crafting their consent forms, maybe they do want to think about whether they want to go back and get that consent. If it is easy enough to do it, like a pop-up is easy enough. If they have to proactively reach out to you, then that's harder, right? So it will depend on what they're using it for. Okay, the other thing that the DPDP Act does have is special protections for personal data of children. So this is another example of things that are not covered under the IT Act. Why do we need a new legislation that talks specifically about privacy and our personal data? It's for things like this. Special protections for personal data of children. As you can imagine, children increasingly, whether we like it or not, use social media of all sorts, right? And so there are special protections on what the intermediary is required to do to identify the age of that person. So at least under the current proposed rules, the intermediaries, so social media platforms, Instagram, Facebook, whatever, they are supposed to get positive consent from the guardian or the parent of a child. Now, could the child say, I'm not 18, I'm 21? Yes, right? And there are so there are still loopholes and all of that. But once it's identified that someone is a minor, then they have to go get the parent's consent. And Google, for example, already does this. If you identify, so our daughter has a phone, but on Google they have parent protection, and there's an option where you can enable parent protection. They cannot download any apps. They can limit their time, all of that sort of stuff. It also creates something called the DPDP board. So that is a special body which will hear complaints under the DPDP Act. So you don't have to go to a regular court and go through that whole process, which is long and delayed and all of that. This will be a special body that will hear complaints only under the DPDP Act. Okay, and then there can be penalties of up to 250 crores. So that is a significant amount, right? So there could be penalties for up to 250 crores for failure to comply with obligations under the DPDP Act relating to creating proper consent forms, relating to having policies in place on how your personal data that is collected is used, and so on. Okay, so one of the interesting things under the DPDP Act is there are no criminal penalties under the DPDP Act. That doesn't mean that there is no criminal remedy at all. Obviously, misuse, fraudulent misuse or criminal misuse of personal data, it would still be a crime. It's just not covered under the DPDP Act. You would look at the other criminal laws to see how that is covered, and we'll talk about that in another lecture. The other important distinction is that there is no, if you remember under the Information Technology Act, we said as an individual you can sue a company and claim damages. The DPDP Act does not have that provision. But that again does not mean that you cannot any longer sue anybody. It just means that you now have to go to court, follow a regular process of showing how there was some harm. Right? You can't just you can go to the DPDP board, and the DPDP board will decide whether the company's policies were appropriate, not appropriate, and if they're found to be insufficient, they would impose a penalty on the company, but they won't give you damages. If you claim that you have damages, you have to go back to court. So that is still I mean, that is unfortunate. Obviously, it would have been better to be able to go straight to the DPDP board and claim compensation by itself. Okay, we are exactly on time. So unless anyone has questions, we are at lunchtime. Any questions?
Jurisdiction is applicable. This is only for violation by Indian companies.
Yes, well, yes, in the sense that the jurisdiction is, as we talked about yesterday, laws in India have a territorial jurisdiction of India, the borders of India. Having said that, there is extraterritorial, it's a good question, because the DPDP Act does have extraterritorial jurisdiction, because it says any data, let me just look at that, any entity that collects an Indian resident's personal data but hosts it outside is still subject to the law, right? So you could still go to the DPDP board and claim they don't have appropriate policies and procedures in place. Now, and we touched on this also briefly yesterday, one of the issues with that is, okay, let's say the DPDP board says penalties of whatever. How is that going to be collected from a company that does not have a presence here? So that would still always be an issue in enforcing decisions. There are, and this is not a new issue, it's not new to the internet. There have always been issues such as this: someone commits some fraud here. Let's say someone, lends B some money, and then B runs away to a different country, right? How do you can get judgment against B, but then how do you enforce that judgment? There are processes in place where every country there's an international agreement where judgments passed in one country can be enforced in another country, except that takes time. It has its own process, but that takes time, and that's still possible in this case as well. Any other questions from the honorable judges of the Supreme Court? No? Okay, so after lunch. Thank you.